Hello, everyone. My name is Jaxon Alston. I am the incoming editor-in-chief of the Journal of Law and Inequality here at the University of Minnesota Law School. I am joined today by Professor June Carbone, who is an expert in family law, assisted reproduction, property law, medicine and bioethics, and also has taught contracts, remedies, financial institutions, civil procedure, and feminist jurisprudence. Professor Carbone was an associate professor at Santa Clara University School of Law beginning in 1987. From 2000 to '06, she served as associate dean for faculty development from 2001 to 2003. She was the presidential professor of ethics and the common good, an appointment that supports ethics research at the SCU's Markula Center for Applied Ethics, something that I'm sure is very timely for today. I also saw that while at SCU, you were the co-director of the National University of Singapore. It's not often I find people who have connections to NUS Singapore. I did a summer program there with
Oh,
the Yale Young Global Scholars years ago and had to go to their campus. And it was a beautiful campus, but I'm pretty
yeah,
sure it's not in existence, or that partnership between NUS and Yale is gone now. But I just found it interesting that that was on
yeah.
your resume.
And I don't know. And let me be clear. What I was it was the director of Santa Clara's program,
Oh,
which was co-run with NUS.
got,
I did not have an appointment at NUS,
gotcha. I see.
and it was
Cool.
fascinating.
I'm sure, yes. In addition, Professor Carbone is a prolific writer in family law, marriage, divorce, and domestic obligations, as well as gender. She is the author of Fair Shake, Women and the Fight to Build a Just Economy, which she has written along with Naomi Kahn and Nancy Levitt, which takes a look at the state of women in the workforce. So for today, I want to talk about the state of the legal community, especially as it pertains to big law. It's no secret now, the current administration has pretty much uh, led an attack on big law, white shoe law firms. He's used, President Trump has used executive orders, taking away the security clearances of attorneys at law firms, as well as uh, threatening to have executive agencies not seek law firms representation, and it's had a disastrous effect on the community. And some law firms have fought back, while others thought it best to capitulate. And I just wanted to hear your thoughts on where we are now and how we got here.
Okay, well, let me start by laying the setting. So, when I first came to Minnesota, I taught a class that was trying to get a handle on how, the post-industrial economy had changed the world. I would always do a class on law professors. I mean, not law professors, lawyers, big law, the change in big law. And it's like everything else in corporate America. You have to start the hallmark of the rule of law and its instantiation in the center of American life is really a product of that post World War II era. So the era that runs from 1960 into the mid 70s is the era of the greatest economic equality in US history. And progressives like to denounce it as racist and sexist. I actually, as a little kid in the 50s, I remember it being racist and sexist. And those things are true. But the improvement in the relative economic equality for white men is an era of the rule of law and the managerial age of US corporations. And in that era, there was a view of a community of interests between capitalists and labor, between the government and private entities, and the institutions of American society were at their peak. Lawyers were incredibly important to all of them. And to capture the role of big law, my husband worked in the early 70s and 80s for Squire Sanders and Dempsey. the Cleveland off, the Washington office of a Cleveland firm. And we used to go every year to the annual dinner dance referred to as the prom in Cleveland. We would fly in for the weekend from Washington. And what was extraordinary in that era, think the early 80s, is that there were three big law firms in Cleveland: Squire Sanders, Jones Day, and Baker Hostetler. And to capture the era, there was a country club. I assume a country club that didn't admit women, and who knows whether it had any racial diversity. And the partners from these three law firms would get together every Friday. They would have an annual lunch, and they would basically talk about what's going on in the city. If you wanted to do business in Cleveland, you had to hire one of those three firms. And if the firms thought what the client wanted was illegal or unethical, they had the power to say no to the client. It's an effective cartel. And they took ethics and also the outer bounds of what it was appropriate to do as a lawyer very seriously. And when you look at that era, the other thing that was true for law firms, the same way it was true for big corporations. In our new book, we spent a lot of time talking about the organization Man in the 50s. Now, he could have been a woman. He's loyal. He is not asking how much is he getting paid. He is not motivated by bonus, and he's going to stay at one firm for his entire career. Well, big law in that era, the name partners who still had their names on the law firms took very seriously the reputation of the firm. They took seriously mentoring young associates in the culture of the firm, the skills of the firm. So today we talk about graduating practice ready lawyers. In that era, it was all, no, law firms didn't want students to have any practical experience. They were going to train them in the
The law
traditions
firm.
of the law, yes, and of the firm's view of the law. So
Mm.
they cared. They cared about who they hired, what the ethics of the people they hired were, and that the way people practice burnished the firm's reputation. Now, I will say there are some firms then and now that had firms, that prize themselves on being tough litigators, and they were cowboys, and it was the Wild West. And some firms prided themselves on that reputation. But law firms took their reputation seriously, and they the typical partner went to work for that law firm right out of law school and stayed for an entire career. If they went into government for a while, they went back to the same law firm afterwards. Okay. So that was the era. And that era could say no to clients. That era is gone. And it's been gone for a long time. And what changed it is the clients got bigger and richer and were ruthless and prospered more by breaking the rules and getting away with it. My awareness of the change came when my husband was at the heart of the savings and loan crisis in the 80s. He was director of litigation for the Federal Home Loan Bank Board, the regulatory agency, that oversaw savings and loans. And one of the things that changed, and you could see it, Charlie Keating did this with accounting firms and he did it with law firms. If his traditional outside lawyers wouldn't do what he wanted, then he just hired new ones. And at the height of the savings and loan crisis, he hired, I think it was Baker Hostetler. It was one of these old Cleveland firms. And he wanted them to fight the regulators. Well, banking regulation requires that the bank turn over every piece of paper in the building to the regulators. This is an obligation that goes with getting deposit insurance. And his banking lawyers refused to do it because it was illegal for the client to refuse to turn over the information. And the client is the bank, not Charlie Keating. So Charlie Keating found another firm that was willing. He hired not the banking experts. He hired the lawyers with no experience in banking because they didn't know what the rules were. That was an advantage, not a disadvantage. They used litigation tactics, hardball litigation tactics. They refused to turn over the information and fought back against well-established government authority. And what the Federal Home Loan Bank Board did is it seized the client accounts of the law firm because the law firm was obstructing the bank examination process, and the federal government went after the law firm and won because seizing the trust accounts of a law firm threatens to shut down the law firm.
Yeah.
And I give you that story because this marked a new era. This marked an era of clients being more powerful than lawyers, of clients saying, okay, you won't do what I want, I'll just go hire different lawyers, of the ability of law firm partners to risk the firm representing an unscrupulous client because Charlie P. Keating paid a whole lot more to lawyers for breaking the law than he would have to pay for them for following the law. And that could make a partner's position in the firm. The thing that also changed in that era was defection. So one of the things, again, and this comes with my new book, the subtitle used to be it used to be Shafted: How Women Lose in a Winner-Take-All Economy. Simon and Schuster didn't like that, so yeah, but the so it's now
Big
Fair
reasons
Shake.
why. Yeah.
They wanted, we won't go into their reasoning, but the thing about the winner take all economy is once you get a more steeply unequal economy with greater rewards, not just for the person calling the shots, but for the lieutenants who implement their vision. So think of the Doge boys who are getting paid a whole lot more than any government civil servant. Um, Once you get that mindset, okay, then what happens is who gets the top pay at these law firms? The people who are the greatest rainmakers with the most lucrative client base. And if you're at a law firm, Mark Elias is a nice example. He's one of, the best lawyers in the country out there challenging the Trump administration, doing voting rights. He has a lot of paying clients. He used to be with Perkins Coie. He was a rainmaker at Perkins Coie. He has a very profitable practice, but it's not in the same league as the top partners at Perkins Coie. Other areas of their business pay more. Okay. So Elias split with them a number of years ago, created his own firm. And that has two advantages. He doesn't have to worry about the effect of the litigation he does on other clients or the client base for other partners. But also, he's now the biggest rainmaker in his own firm. He gets to dominate. It is not a partnership of equals. It is the biggest rainmakers get to dominate. And I'm not saying Elias is doing anything inappropriate. I want to be clear. But I'm saying not just do the biggest rainmakers get to dominate the firm. It is not first among equals. It is not among equals. They also get to allocate a larger share of corporate profits for themselves. So if you've got a client base that is lucrative, but not as lucrative as other parts of the firm, you have less power within the firm. And and you may want to defect. So if you defect, you go to a smaller firm or create your own firm. And then within that firm, you're the big cheese and you get a disproportionate share of total profits. When that whole shift occurred, where, you know, the people who go to work for the firm right out of law school and make partner and do well are not loyal to the firm. They're always threatening to defect. And they take an entire client group with them and they take the associates and other lawyers who do that work with them.
Which in
The
turn makes
firms
firms weaker.
the firms churn.
Yeah.
Okay. So the ability of the firm to impose a firm culture and make it stick
Mhm.
becomes weaker. The collective interests of the firm as a whole become less important than the ability of the biggest rainmaking groups to dominate the firm culture. And the firm is at risk at any given moment of the most lucrative, or typically not the most lucrative, but the second most lucrative parts of the firm to defect if they can get more for themselves somewhere else. So these large firms that in the olden days were founded by these named partners, very prestigious named partners, and cared about the reputation associated with their name. Now, these large firms with lots of power as firms are at constant risk of defection of various groups within them, and they're always seeking to recruit new groups who come in. So it's not, it's not the firm as an entity that is fixed with a secure client base and a secure reputation. It is a firm whose ability to earn $1 million a year partner profits, that the top partners make more than 1 million a year. And then very successful, but not as lucrative partners are making several 100,000 a year. Okay. So you're building in these differences, and the risk of defection is great. And the nature of the client base is constantly turning, and you're always bringing in new business because you need new practice groups to replace the old practice groups that left.
Yeah.
So think of law firms as fluid, dynamic, always concerned with the bottom line. And if they're not concerned with the bottom line, then some group within the firm will defect. Okay. Now let's talk about what happened to Trump. And I will say, I did talk to some of my law school classmates who are partners at these firms. And I was in on some phone calls where they tried to explain themselves.
Yeah.
And here's what they said. What the Trump administration did that was really destructive wasn't the executive orders. The executive orders are clearly unconstitutional. Lower courts have already ruled to that effect. And the you know, they're almost laughable as a legal device. Okay. And they were prepared to fight those orders, and they felt they could have won. That's not what the Trump administration is doing that is so destructive to them and threat. What they're doing is saying, we won't return your phone calls. We, the entire federal government, will think like Trump. We play favorites. We do favors for the law firms that support us, and we freeze out the law firms that don't support us. So you can take Paul Weiss, but you can take any number of the firms that have caved. And the type of practice that is most vulnerable to this is the mergers and acquisitions practice. So if what you're doing is advising clients on mergers and acquisitions, you've got one giant firm that wants to, well, take TikTok. TikTok, we have, I think it's Amazon that wants to acquire TikTok. And
Most,
it's kind
yeah, most recent bid is from Amazon.
Yeah, so let's take that as an example. And I know nothing about the backstory of that. Okay, well, the Chinese government has put a kibosh on it for the time being. But Jeff Bezos knows if he wants to acquire TikTok, he's got to be on the good side of Donald Trump. There's no way he could acquire TikTok without being on the good side of Donald Trump. And if he's trying to acquire TikTok, and let's say he hires a law firm that's going to manage this for him, when you're doing that kind of merger, the lawyers are often paid on a percentage basis. That is, if the deal goes through, they get a certain percentage. So it's like a contingency fee kind of basis. That is, the lawyers only get paid if the deal goes through, but they get paid a lot because they're taking on the risk the deal won't go through. And when you look at a deal like this, it involves a couple of things. First, there's the skill in negotiations. These deals are enormously complex. So the lawyers, what they need to know is how to arrange the financing, how to structure the deal so the other side will say, yes, this is not a zero-sum transaction. This is a win-win transaction. But they also need to be aware of whatever government regulation exists in the background. So if there's a potential antitrust case, you may need pre-clearance review. There may be various in something like acquiring TikTok, there could be half a dozen regulatory agencies involved. And what the lawyers are doing is, troubleshooting and wargaming. What are the potential regulatory objections to the merger? How do we find out in advance what the regulators want to allow the deal to go through? What are the legal constraints about how we structure the deal? Okay. Now, in doing this, you want to think of this as not the lawyers go to the library and research what the law is. You want to think of it as a fluid dynamic with negotiations going on simultaneously between the companies to be merged and the various federal agencies that are involved. If Donald Trump is saying, I don't like your lawyer, I won't approve anything, and Donald Trump is saying that and did that in the first Trump term, you're dead as an M&A lawyer. If the various agencies are saying, well, Donald Trump might approve it because he likes Jeff Bezos, but we don't like Paul Weiss, and so we just won't return Paul Weiss's phone calls when they call us up to find out what the attitude is toward this structure of the deal as opposed to that structure of the deal in terms of compliance with the various federal regulations in the background. You're dead as mergers and acquisitions lawyer. And so the part of the firm that does mergers and acquisitions, which is often the most lucrative part of big law, the lawyers handling those cases, if they sense their clients have nothing to do with Donald Trump, clients have nothing to do with this dispute. Those clients are nervous about having a firm that's in Donald Trump's crosshairs. The clients are saying, we'll go elsewhere. And the lawyers who handle those clients are saying, we'll go with them. And the competitors to the law firm are saying, hey, you guys are the biggest rainmakers in the universe. Come to us. We'd love to have you.
Yeah.
The entire firm is at risk of imploding.
And the bottom falls out, basically.
It bottom falls out. And so a firm that only does litigation, the gunslingers that only do litigation, they tend to be less ethical in some ways, but more ethical in other ways. Those guys can afford to fight. It's the firms that have clients that, what they're really doing is schmoozing with the federal government. And, most of corporate America is schmoozing with the federal government on something. And when I say schmoozing, it can be legal, it can be shady, it can be above board. It can be simply we call up the regulators and find out if we structure the deal this way as opposed to that way, are we going to run afoul of the way the agency is thinking about how to enforce these rules.
Right.
If they won't return your phone calls, you're dead. And this whole area of practice is dead. And it will defect and go to another firm.
I think, but to like the average ear, a person who's not steeped in the law and doesn't know how big law works and whatnot, they hear, okay, Skadden Arps agrees to do $100 million in pro bono or in services that the administration is more sympathetic to. And then they do the math and they're like, well, Skadden, a firm like Skadden and others, they're billion-dollar firms. If they have $100 million, so to speak, this is simplifying it, but if they have $100 million to give away, essentially, don't they also have $100 million to fight the government as well, especially as a billion-dollar law firm? Like, is this
Okay.
risk of
Now,
bottoming out that scary where they're still willing to capitulate in this way?
so here's what's happened. And this is, Trump, again, some of the economic stuff I'm involved in, people debate how stupid it's right. And they think he knows nothing about economics and this tariff deal is really stupid. I leave that to other people. What Trump understands two things. He understands power and he understands how to feed a crowd. He's very good at that. His emotional IQ is extremely high. Whether or not I really don't think he could get into law school or pass if he did. It's a very different kind of IQ. But
Yeah,
his emotional IQ is off the charts, and
very
his
good at
biggest
knowing which people to be around at a certain time too.
and his biggest instinct is for power.
Yeah.
So here's what happened. And, as I said, this is the first of the law firms to settle with Trump. First of all, they got a good deal. And this is what, was in the conversations and had one of them say this to me directly, and it's there in the press. It's their official position. Trump met with us for 2 hours in the Oval Office. He had nothing better to do than uh, deal with us.
Wow.
And what Trump really wanted, of course, was the victory, the ability to declare victory. The first firms that settled with him felt they got an incredibly good deal. And this is what they say. We do tons of pro bono work anyway. Yes, it looks like a big number, but it's not more than we do routinely. And we reached an agreement on our terms. Our terms were that we bring no pro bono cases that our pro bono committee wouldn't approve on the terms in existence at the beginning of the negotiation. And this is true for Paul Weiss in particularly, one of the categories, or two categories of cases that Trump wanted them to bring, one are cases involving anti-Semitism. Paul Weiss is a Jewish law firm. I mean, or at least it was founded as a Jewish law firm originally at a time when Jews were frozen out of the mainstream white Jew law firms. Bring cases challenging anti-Semitism that our pro bono committee approves. What could make us happier? So they were the first to cave, and they felt they agreed to nothing that they wouldn't have been willing to do anyway.
Mm,
Now, Trump celebrates this as a great victory. The media, the headlines are $40 million for Paul Weiss. It was, as the first to settle, it was 40 million.
mm,
And that figure does not sound like a large number to them because the way they calculate the pro bono work they were already doing, and firms like this do a lot of pro bono work. Some of it is real pro bono work. Some of it is, things that the partners want to do because it helps bring in other business, or you're doing a favor for a friend who pays a lot of money for the firm and paying work. So I want to be skeptical about what pro bono is, but some of it is real pro bono work, and they're only too happy to bring cases challenging anti-Semitism, something they'd be willing to do anyway, and they control which cases they bring. So that's their justification. Now, that again, but it's also a row of dominoes. They're the first to settle. They get the best deal because the first to settle gets the best deal. The price goes up. And it's not clear. And I have not followed every successive firm that settles.
I mean, there's one every other week now.
Yes. The people who settle later are going to have to pay more to settle. And what does Trump really want? He doesn't want just, some settlement of principle. He wants to humiliate them. And that's what's about to happen next. And I think the next stage is going to be both qualitatively and quantitatively different.
Hmm. I think the effect on pro bono work is something I also have a question about. Like, what is a pro bono going to look like going forward in white shoe firms? And then I'm thinking about the um, effect all of this is having, this administration is having on freedom of speech as well. Because now, for example, if a firm still decides to represent someone who was sympathetic to um, Palestinian statehood, for example, does that put a target on the firm's back for then the Trump administration to come back around and say, hey, I don't like the way you do this. You did this. I don't like the way that you decided to represent this person. This is considered anti-Semitism, or this is considered something that is um, antithetical to what the United States stands for. And then does that have a chilling effect on other firms that may not have been targets of the administration anyway?
Yes.
Got it. Well, that's extremely terrifying because
Yes.
I'm assuming there's a large swath of vulnerable populations that, for those that don't get representation by legal aid resources or organizations on a large scale like the ACLU, but on a smaller scale as well, you know, fancy white shoe law firms sometimes were a failsafe or filled in the gap where there was representation still lacking for vulnerable people. So going forward, is there a risk of these sorts of like marginalized identities being left behind because law firms are looking at their bottom line and they're going to say, you know what, it's Trump's way or the highway. This is where we're going.
Yes. But it's not just marginalized people. I mean, what is he mad at some of the law firms for? Their willingness to represent the special prosecutor, Jack Smith. Okay. Or their involvement with Mueller, the former Republican who's a former FBI director. These aren't marginal people.
Yeah.
And frankly, some of them were appointed by Donald Trump. Mueller was free. I mean, Mueller was appointed by the Trump administration, and he is a former Republican, head of the FBI. So, when you look at who he's going after, it's all personal. And then it's political. And yes, it is marginalized groups. I mean, you have an attorney who represented, one of the foreign visa holders who has been detained because of support for Palestinian causes. Yes, the lawyer has been detained too. Now, the lawyer, you know, is an American citizen, was quickly released, but yes, he's doing exactly that.
I also want to talk about the effect this is having on higher education. Um,
Let's let's not switch yet. And one more
okay,
topic I
okay.
want to bring in.
Yeah.
I think we're at an inflection point. And again, I started off trying to set out as clearly as I could why big law would cave. And I'm going to talk about that with respect to universities in a minute. I think it's the same story.
Yeah.
But I think we're at an inflection point, and there are three or four things happening make this an inflection point. Um, the first is that this is not costless to any of these law firms. They've had lawyers resign. It is going to affect their ability to recruit, and they're not completely out of the woods. Secondly, Trump has now, I mean, his next move has been to say, not to the first of the firms to settle, but the ones that have settled more recently, okay, I now have a list of cases I want you to bring. And these cases, many of these cases are like all things Trump, dubious legality, dubious in the nature of the arguments he wants them to bring, may clash with lawyers' ethical commitments. And I want to emphasize, because this is happening in my old office at the Justice Department. I worked for the Civil Division of the Justice Department. We defended the bad cases in every administration. Sue the federal government, say something the federal government is doing is illegal or unconstitutional. We were the lawyers who defended those cases. Mostly we're defending somewhat hapless federal agencies, sometimes evil federal agencies, more commonly hapless federal agencies. But we had certain rules in the office. One was the laugh test. We would not make an argument in court that we felt couldn't pass the laugh test. The Trump Justice Department is routinely making arguments in court that don't pass the last laugh test. They have cashiered a Justice Department lawyer for failing to obey, superiors. Now, I think what the lawyer did, though I'm not positive on this, was a failure um, to argue that the deportation of the guy who in Maryland who was an administrative mistake, person who was here legally with a protective order saying he could not be deported, that the Justice Department didn't want him to tell the truth about what happened in that case. I
Yeah.
think that's the reason he was placed on administrative leave. But I don't know that. Um, but there are
It
all
would
kinds
track
of
because
things.
there was a congressional hearing. It was either early this week or late last week, and she works at the DOJ, and she reported when she was in front of Congress that people showed up at her house.
Yeah,
She thinks that it's from the DOJ, pressuring her not to testify or say something to the Congress people.
right. So the thing I was saying is this is going on wholesale. I mean, the lawyers in the case involving birthright citizenship have been criticized by a number of judges for making arguments that are laughable. Okay. A number of lawyers have made statements in briefs they then disavow in court, so they're taking inconsistent positions. These are all things that violate, the norms of professional integrity for lawyers. I mean, some of them are ethical issues, lying to the court, but
Right?
other things are not ethical, but issues of competence. And it happens because, for a variety of reasons. I'm saying these white shoe law firms, if they take on pro bono projects, some of those projects are laughable.
Yes.
The legal basis for them is laughable. The reason the Trump wants to bring them is harassment. This is an abuse of the legal process. The lawyers can be found, they can have sanctions imposed against them if they abuse the judicial process. There are, a variety of things involved in doing Trump's will that will get you in trouble. And so that's where we're heading. Again, if Paul Weiss is only bringing cases it would have been willing to bring anyway, the optics are terrible, but substantively, they don't feel they sold out. Um, if lawyers are bringing laughable cases that will get them in trouble as a matter of their legal reputations, that's a different matter. And that's what Trump is trying to get them to do.
Yeah.
I think they have to fight that. Now, how they fight it, etc. And the
Especially after
deals,
already making a deal.
yes, after making a deal. But I mean, again, if the deal were a contract, um, they can say we never agreed to do anything that is unethical or would violate our professional obligations, and that will be implied into. I mean, if you think of contracts as having an implied obligation of good faith and fair dealing,
Yeah.
they would win on those kinds of claims, absent something explicit to the contrary. But that's not what's going on. It's not what they agreed to.
I wonder, I guess that brings me on to the next question. Just, I don't mean to interrupt, but now I want to know, like, what are the mechanics of these deals? It sounds like they aren't actual contracts. Like, how does something like this work?
I don't know. I mean, presumably what happens is, um, you know, and I would assume that Trump would want this in writing, that the firms agree to something. And this statement that they agree then becomes the grounds for Trump rescinding the executive order. But I don't think, if you watch the history of Trump, the Trump administration, Trump in his operation in business, he doesn't comply with the Administrative Procedure Act. He again, he likes for things not to be in writing. He likes for there to be no record of negotiations. And then he gets to make up whatever he says the agreement is. And then what he's doing is threatening to reimpose whatever the sanctions were that he withdrew for the agreement. So that it's not a question of his legally enforcing a document. If that's what were going on, the lawyers would have lots of defenses, not the least of which are duress. It would be an unenforceable agreement because of the rule of duress. And they could litigate it for years and he would never get a resolution. So, in the same way, Trump uses delay to do whatever he wants that's illegal. And then it takes years for the law to catch up with him if it ever does. The lawyers could play the same game. Trump could never enforce any real agreement against them. But what he could do is then say, I get to reimpose. So you settled and promised me all these things, and I withdrew the executive order. I'm reinstating the executive order. And you're now in a worse position than you were before you agreed. That's his threat.
So how does this leak into the universities and the situation there?
I think it's the same story. First, again, in our book Fair Shake, one of the shifts we document is the move from institutionalized power, the CEO of a company as a steward of the company's long-term interest, answerable to multiple stakeholders that include customers and employees, to the CEO as dictator. Alan Greenspan, the former head of the Fed, spoke admiringly of CEOs had become dictators. That means they get to run their companies however they choose, and the only real check on CEO power is the stock market. Okay, it's the price of shares, which can be manipulated. Elon Musk, Elon Musk is found guilty of securities violations by the SEC. They gave him a slap on the wrist, a personal $20 million fine. And he won his most recent securities suit against private securities lawyers. But he's a walking,
Yeah.
walking effort to manipulate the stock market. And share price is the only real, share price is what makes CEOs rich. and it's the only real check on their authority. And they can manipulate the metrics. Okay.
Yeah.
Now, given all that, if you see this as personalized power, he's doing the same thing with universities he's doing with law firms. First, he sees university, when you look, fundamentalist churches are now the union halls of the Republican Party. Universities are the most visible institutional support for Democrats. And we know we're in the middle of a university. It's not busy organizing people to vote for Democrats. But the Republicans see universities as the hotbed of opposition to them, the counterpoint. The most educated right now, the Republican Party is losing people with college degrees. It's not losing any, the
Yeah.
people, they're gaining the people with that.
Historically, strongman regimes and the emergence of them, the universities, the educated elite, as they call it, are usually the first set of people to be attacked, lawyers included.
Right. And then Trump is choosing the universities to go after based on which ones dissed him. My guess he's never forgiven Columbia for not admitting him back when he went to Fordham. Um, but he has also had fights with Columbia University over real estate stuff and lost. And you have and Columbia has been ground zero for the Hamas war protests.
Yeah.
So you have lots of things, lots of reasons for him to focus in on Columbia. And Columbia, well, all universities, and let me talk about vulnerability for a minute. So when I was talking about law firms, I was ending by saying what I think will happen. I think they're going to have to fight back because I think he will inevitably go too far. And secondly, the law firms in a position to fight back best are firms like Mark Elias's firm. It's a litigation firm. It's not doing M&A. It's not doing the kind of work where you need the government to return your phone calls. And it's set up to take on unpopular, politically charged and unpopular clients. So firms like that can fight back. Firms that primarily do litigation can fight back. And at
Are
least,
many?
hmm?
How are there a good amount? Are there enough?
There are a bunch. And then there are a bunch where they've made a calculus, they gain more by fighting back because the cost of settling now has gone up.
Yeah.
So there are more firms, with less to lose from fighting and more to lose from settling than the first rounds of settlements.
Right.
So the
Okay.
price of settling has gone up. Trump's behavior has got more extreme. And there are a bunch of firms that are simply less vulnerable because of the nature of their client base, or because the price of settlement is so high, they're going to lose anyway. And I think that's shifting. I think we are at an inflection point in that shifting. Now, when I do the same analysis with universities, what I say about universities are the most vulnerable universities. Columbia is certainly one. Minnesota is going to be one. There are a number of others. I mean, we may not be as high on the hit list, but Trump has identified the 10 universities with the biggest endowments is going after that. And the thing about major universities are that uh, they are, I mean, and again, the University of Minnesota as a land grant institution with a public mission, a huge part of the money at the university comes from federal research funds. So when you look at research in the United States, and I spent some time looking at biomedical research, in 1960, the federal government funded 90% of biomedical research. The lines cross and the majority of funding becomes private in 1980. Um, but when you look at what the federal government funds versus what private parties fund, the federal government continues to be the major source of basic research. Private companies are quite happy to fund commercial research. That means research that you can take that research and turn it into something, a commercial application you can sell within 6 months to 3 years. If it's longer than that, the federal government needs to be involved with the funding. And in biomedical research, the federal government funding remains important for the base, the research that isn't going to pay off for maybe 10 years, if ever. Okay.
Yeah.
So big universities depend heavily on that research. And that research doesn't just fund the immediate projects. It's like if you don't get this funding, So you do other projects. The research includes a large component of a federal science grant is funding that doesn't just pay for the marginal cost of undertaking this project, but rather for the funding of the construction of the lab, paying for the building, paying for professors who may be tenured professors with long-term contracts. So what's called overhead in grant world, the overhead is creating the facilities that allow the research to take place. And a high percentage of federal grants goes to overhead. And that overhead is what allows the universities to create state-of-the-art research labs, to hire state-of-the-art professors who are top of their field. So the most prestigious universities attract a huge amount of federal grant money that then funds the base. Now, in today's world, and I could go on about stem cell research because what happened when I was out in California and the Bush administration cut off stem cell research because it involved embryonic stem cells that were taken from fetuses. Um, Stanford got a $60 million gift to construct a separate building to do with stem cell research. And the state of California, which wanted to be a pioneer in biomedical research, passed a proposition for the state to fund that kind of research. Okay. But it's enormously important to the role of the United States as the research center of the world
Right.
is that money that funds basic research. Okay. So the universities that are most dependent on federal funding are the most vulnerable to Trump's threats. And he has, what Doge has been busy doing is willy-nilly slashing whole categories of federal research unilaterally with, reducing the amount that goes to overhead. Um, and again, if you apply a Trump Musk theory of the world, a businessman theory of the world, you want to slash funds, costs everywhere, and squeezing people is the way to, slash funds, and you can do the same stuff for less money. Not in this world. These are not profit centers. They're not driven by private market incentives. They're driven by love of the research. And you become a major research center by creating a critical mass of people who talk to each other. And so, yes, you could do the same research for less money, but that money doesn't just contribute to the immediate project. It contributes to the next 10 projects the federal government is going to want to fund at these universities. So the major university research centers are incredibly important to the role of the United States as a scientific and technological leader in the world
Right.
and to the development of the critical mass of scientists, et cetera, who I think will go abroad. I think the next generation is about to go abroad.
The
So,
brain drain that this is going to have, I think, is going to be disastrous, frankly.
right. So the universities, when I was at UMKC and UMK, I mean, Missouri, UMKC is a wonderful place. Missouri is a benighted place. It is now 50th in the country in teacher pay, 49th in the country in education support per student. And it's bled the universities dry forever. I mean, Kansas, which is right next door and also conservative, but less MAGA, is it funded its universities. It has some first-rate universities. The University of Missouri, I mean, not that I'm saying bad things about the University of Missouri Columbia, but it has starved its universities forever. This is part of the mindset of the plantocracy that came out of the South. I mean, the South did not have a public education system until
No.
after the Civil War. New
Yeah.
England and the Midwestern states led the world. The U.S. was the best educated country in the world by 1900, and women were better educated than men because New England, the Western, and Midwestern and mountain states believed in education. And we got the land grant university system only after the South seceded. It was passed in 1863. The South had been blocking it. The South has never really believed in education, although I will say Alabama does believe in the University of Alabama today. And that's changed a bit.
Yeah.
But for the masses, education for the masses, has never been part of this mindset.
Right.
Okay. So now let's switch to universities. So universities are incredibly interdependent on all kinds of federal expenditures, on subsidization of student loans, on, as I said, the major research grants are the most visible. And then there are all kinds of other things. And when I was at UNKC, the conservatives on the board of trustees, and it was run by businessmen who thought like businessmen, and they were clueless about the academy. I mean, it's like Doge. They understood nothing about what makes universities tick, and that your most valuable employees at a place like UMKC, which is not a prestigious school, are the people who love teaching and do it because they love teaching. They can make a lot more money doing other things with level of skill they have. And they diss those people right and left. And what the business types wanted to do is basically have the universities become tech centers funded by external grants and shortchange everybody else. Squeeze the humanities, which after all are too woke. And and they viewed a lot of non-STEM education, STEM, science, technology, engineering, and medicine, as a waste. Why do we bother spending money on these things? So if you look at what the Trump administration is doing, it's both slashing the science part, where universities are most dependent, and using this as a club to attack what they view as the woke parts of the university, which
Right.
they view as their enemy. And the first universities to be targeted are Trump's personal enemies, but the rest of us are next.
I'm sure it sent a shockwave the way Colombia uh, gave a settlement basically with Trump. And it was interesting to find out that the $400 million that Trump threatened to take away from Colombia was about 20% of Colombia's operating budget, even though they have billions in an
Yeah,
endowment. So I'm
yes.
sure there are universities with way less money in their endowment, let alone way less money, way less money to use for their overhead and operating budget, where it could be instead of 20%, I don't know, 40, 50, 60%. Not every university in
It
Columbia
doesn't it actually doesn't work like that. So
doesn't. Okay.
the major research universities are the most dependent on federal science grants.
Okay.
So if you look at the liberal arts schools, I mean, some of the university presidents who have been the most courageous in speaking up, the president of Wesleyan, the president of Princeton. Okay, Princeton is my alma mater. I'm giving a talk there. I'm very pleased. I'm going to my 50th college reunion.
Congratulations.
and 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 I was invited to be on a panel, and so I am going, and I'm proud of the president of the university for speaking up. But Princeton is a very prestigious university. It doesn't have a medical school, also doesn't have a law school. Its priority has been undergraduate education. And so, although it's quite wealthy, it is not as dependent on federal grants as, say, Columbia is
It
or
has
Harvard.
more room to speak up.
Yes. And a school like Wesleyan, that is a liberal arts school, is also freer to speak up. And among law schools, I was interested in seeing the UVA faculty has just, signed some major, letter of protest, been getting some publicity. But the law school is not dependent either on the university or the state of Virginia for its funding. That makes it easier for it to speak up. Now, that doesn't mean there isn't an element of courage in this. They could still be targeted, and Trump could go after the university, even if the law school is not dependent on the university. But the universities are quite vulnerable. Now, the question then becomes how are they, if Trump goes too far, and in Colombia, I just want to emphasize, is particularly vulnerable. They have an acting president rather than a permanent president. The prior president had been forced out. Trying to think whether Bill Ackman, who's been speaking up recently, had a role in this. He's a major funder. But Colombia has also been torn apart, both by pro-Palestinian protests and charges of anti-Semitism coming from people like Bill Ackman. Maybe he was were involved in pushing out the Harvard president. I don't remember, but he's a really rich guy on
Yes.
Wall Street, who is a big Trump supporter, and he had a major role in pushing out a university president. Okay. And the feeling of anti-Semitism among well-funded, Wall Street types who give a lot of money to Ivy League schools in the New York area it's an issue. Um, and it's more and more toxic. I mean, we have our own issues in Minnesota. They're nothing like the issues in New York City.
As a Carleton graduate, I am crossing my fingers that it also stays out of the fray. It's also a college that doesn't have a law school or a medical school, so I think they'll be fine too, but I'm crossing my fingers. We're nearing the end of the podcast, but I wanted to know what you see legal education looking like over the next 4 years as things like this continue to progress.
Well, so there was this. So when the financial crisis hit in 2008, usually financial crises are good for law schools, and in fact, we had more students. But then what happened is the big companies stopped hiring big law to do routine legal work. They felt pressured by the financial crisis. And this is part of what changed big law, is that they would only hire these major law firms for the break the company cases, not routine legal work.
Okay.
And big law stopped hiring our students. And you had the recession, which because of Mitch McConnell and the fiscal cliff, cutting off federal stimulus prematurely, the recession caused by the financial crisis didn't really, um, the economy recovered. It was recovering in 2016 as Donald Trump was elected for the first time. What people fondly remember as the good Trump years were product of the recovery as a result of Obama era policies. And it was delayed by Mitch McConnell personally, okay, and Paul Ryan, Speaker of the House. So what happened is this downturn, this draw in legal education. When Trump was elected, you both had a better economy and people wanting to fight Trump. Our student body is more liberal than it was before Trump was elected. My prediction for Minnesota and for comparable schools is we will have more applicants. Partly because I predict there will be a recession. The odds are pretty good. Because private business is not looking so attractive, and idealistic students want to fight this. And law is a good place where people want to fight this. So I suspect the number of people going to law school, unless Trump creates a global depression, which is possible. I would not rule that out. But right now, it looks like we're only going to have a recession, and that in general would be good for law schools. Now, how does the ability to fight back change? Well, the thing about bullies and about authoritarian leaders, once they weaken, the knives are going to be out for them. And Trump, precisely by moving fast and breaking things, the number of people who are out to get him are huge. And I don't mean Democrats. Democrats are hapless. We know that.
Yeah.
I mean, Wall Street now feels he needs to be reined in. He caved because the bond markets were about to crash, and the bond markets were apparently triggered by actions in Japan and China. So foreign leaders are beginning to get a good sense of how to fight back. Republicans are incredibly nervous about a wipeout. I would be stunned if Democrats don't sweep the midterms. And the moment they do, the single thing they can do after that is to launch endless hearings that expose the dastardly and illegal acts. I would like to see, and my hope is I think we need to think more systematically about how to empower private lawyers. So my son, full disclosure, is a partner with the plaintiff securities firm in San Francisco. He's busy, he's sued Apple and other big companies, not Elon Musk. And Elon Musk won his most recent private securities suit. in front of a jury. But I'd like to see, and one of the questions I've been asking is who can sue on behalf of private parties? So my colleague Richard Painter, was very much involved in the emoluments clause litigation in the first Trump term. Basically, every Trump cabinet member and Trump personally is involved in grift. The stories were out this
Nazi
morning,
grift, yes.
and that Trump engaged in a series of trades before calling off his tariffs for 30 days,
Yeah,
and he didn't call them off completely. That's insider trading. It's illegal. I mean, there are chapter and verse of illegalities conducted by Elon Musk personally in a variety of ways, uh, by um, by various cabinet members in a variety of ways, by Doge activity, by Trump personally. The entire crypto universe is built on fraud of various kinds. I predict that there could easily be a crypto bubble followed by a bust. And if the bust is big enough, the knives will be out and there will be illegality all over the place. And the question is, who can sue to redress those wrongs? Trump has neutered the federal government as a source of lawsuits. Um, but um, that doesn't neuter the state attorney generals. It doesn't neuter the private bar. And the people who will bring the suits are not the white shoe law firms. They are the scrappier, litigation-oriented firms willing to take on these cases. And that's what I'd like to see an expansion of, is private litigation or the states fighting back.
interesting. Now, I said we're heading to the end, but one last question, and it's the role of the Supreme Court in all of this. Because one may say, the law firms aren't necessarily coming to save the day. So the Supreme Court is going to have the last say in terms of how Trump is allowed to treat law firms. What do you see? Like, how do you see the chance of that happening? Do you have much faith in the Supreme Court, its current makeup, in them actually helping the situation? Or, yeah.
So Lee Lippman at the Michigan has a new book coming out called Lawless.
Mhm.
And I'm very jealous of the title. Uh, I wanted to describe corporate America in those ways. The rise of the current generation of oligarchs is lawless. And she has used that to describe the Supreme Court, and I will leave to her what that's about. Um, that said, uh, I think the assault on law firms and on an independent judiciary is deeply disturbing to the Supreme Court. And what you've had, but I'm also incredibly cynical about the Supreme Court.
As am
So
I.
let me give you my hope and my pessimism. The Supreme Court this week has issued a series of rulings, on the shadow docket on these appeals from TROs where the court doesn't fully brief anything and then issues rulings and has basically said Judge Bozeman has no jurisdiction over the cases protesting deporting people to prisons in El Salvador. But it also said, with all nine justices agreeing, or at least seeming to agree, that if he wants to invoke the Alien and Sedition Act, that he needs to give the people who are the subject of a due process an opportunity to be heard in court before they're deported, an opportunity to raise constitutional challenges to the act, an opportunity to contest the factual allegations against them. And this must take place before anybody is removed from the United States. Now, they said this in a set of opinions in response to a TRO, in which they said the court didn't have jurisdiction. So that's weird. But they simultaneously did two things. They affirmed in ringing terms the right to due process that suggest that they would rule against any of these actions being taken against law firms if given the chance. Secondly, they did so in a way that deprived the judge who was willing to rule on these things of jurisdiction, saying the correct form was in Texas, that it was through a writ of habeas corpus, which is an individual suit, rather than a class action of some sort that operated more generally to prevent the government from taking action. So they simultaneously, in ringing, inspiring terms, said people accused of being in the dangerous immigrants who are in the US illegally have due process rights. And that's important. And here are all these roadblocks to actually enforcing those rights in a way that where you could end up in jail in El Salvador for years before the issue you raise is ever heard. And they did that deliberately. So I don't know what to think of this court. And
Yeah.
I think that's what the immunity I can justify in my own head, Chief Justice Roberts' opinion in the immunity case, saying Trump is immune for actions taken as part of his official acts while he's in office. I
Mhm.
can I can say this is protection from Joe Biden for a vengeful Trump. I can imagine that. What I can't forgive them for is delaying issuing the opinion until the last possible date for doing so, so the case could not possibly be heard before the election. That's unforgivable. That's what I think of the possibilities.
Well, there you have it. Thank you so much for joining me today, and I really appreciate you giving us your thoughts about this current state of the legal community. Thank you so much.
Hey, I enjoyed it. Happy to do it.